Cameron Ownbey was charged with 1 count of attempted rape in the second degree and 3 counts of assault in the second degree, following an incident where the victim, N.F., alleges she fell asleep after some alcoholic drinks and woke to Mr. Ownbey spooning her and holding a substance to her face. In 2017, the two met through a Craigslist ad that he posted in which he stated he wanted to impregnate somebody. After they met, N.F. decided against a relationship with Mr. Ownbey, but they remained friends. They visited Las Vegas, and the two began a business relationship. After this incident and following the trial, he was found guilty of assault in the second degree with sexual motivation. He is appealing his conviction, arguing the trial court misapplied the rape shield statute. The trial court erred by allowing Jessica Johnson to testify as an expert to rehabilitating NF. The special verdicts returned by the jury are not supported by sufficient evidence or are unconstitutionally vague, and the DNA collection fee and victim penalty assessment fee should be struck. Let's take a look at the arguments.
In the second case of State versus Ownbey, the attorneys representing the parties are in front of me. They appear to be ready. And counsel for appellant, if you would introduce yourself and let me know how much time you'd like for rebuttal, we'll be getting underway then.
Moses Okay, on behalf of Cameron Ownbey, I would like to reserve 5 minutes for rebuttal.
Okay, and you'll notice that there's a little box right in front of you. That's a green light, yellow light, red light. The green light means that you've got time. The yellow light means you're into your 5-minute rebuttal, and the red light means that you're all done. So I will try to keep pay attention to the yellow light to warn you, but it's really your responsibility to know once you get into the rebuttal time, okay? Very good, you may begin.
Good morning, may it please the court. We ask the court to reverse Mr. Ownbey's conviction for assault for 2 reasons. The trial court improperly allowed expert testimony to bolster the complaining witness's veracity, which invaded the province of the jury. Second, the trial court misapplied the rape shield statute and evidence rule 613 and denied Mr. Ownbey critical evidence for his defense. Without this evidence, Mr. Ownbey couldn't challenge the prosecution's new spin to explain the discrepancy between the complainant's statements at the hospital and the new version from her recent recollection. Mr. Ownbey's cross-examination was...
What statement to the police did Mr. Ownbey wish the jury to hear that the Superior Court precluded?
When the defense counsel had interviewed the complainant and asked her whether their trip to Vegas turned into anything sexual, she said she told Mr. Ownbey there was a possibility things might get a little sexual with another couple, and then explained why they didn't end up engaging in sex. So,
how many months before the incident in question was this Las Vegas trip? My understanding is that it was sometime the year before, but it's just not clear when a year before.
the record shows that it was January 2020, and then the alleged incident was March 2020.
Okay, so about 4 months.
Yes.
Okay, thank you.
Would that be 2 months?
2 months.
Oh, I'm sorry, I thought you said.
January 2020,
Okay.
and then the alleged incident was March 2020.
I'm sorry, thank
Okay,
you.
and the trial court excluded that.
Yes.
What if any other statement to the police by NF was excluded by the Superior Court?
There was this statement. She was being questioned about whether they engaged in bondage type stuff, and she refused to answer the question and eventually said there were several conversations, but the conversation that stuck in her mind was the conversation explaining her idea of consent. So she never quite really answered that question, despite being shown her statements about bondage type stuff.
Okay, and do you have the page in the transcript where both of those statements were precluded by the court?
So, second volume report of proceeding 536 to 538, I believe.
I think that's correct. That's the offer of proof.
those
Yes,
points?
the offer of proof.
Okay, thank you.
I'll make sure to verify that.
Well, I don't want you to spend your time on that because we can find that. What questions did Mr. Ownbey wish his trial counsel could have asked NF, but was not able to ask because of the court ruling?
So when cross-examination resumed, she was still being evasive about this, whether she discussed having a sexual encounter in Vegas. Report of proceeding 543. At first, she claimed she didn't understand the question. Then she said, I never had a conversation with him that we were going to have any sort of sexual encounter. After she was allowed to review her prior statements, she now vaguely said they could have discussed the possibility of sexuality in Vegas, but it was not a sexual encounter discussion.
Okay, in reading that, it appears to me that counsel was allowed to ask the questions. It's just that counsel didn't get the answer that he had hoped to get.
Well, so even
And then counsel wanted to use the prior statement, and that was not allowed. Is that correct?
yes, that's correct.
Thank you.
So the real question is, what should the court do if a witness is being evasive even after being given the chance to explain or deny her prior statements? If she denies, the court must allow evidence to impeach her. And if she explains and gives a different spin, the court must allow evidence to controvert the new spin.
How does that not conflict with the statute, where the statute says that shouldn't be used on issues of credibility? That's specifically why the statute was put in place.
So this goes to the crucial evidence. She's denying ever having sex or ever having talked about sex. And even if she's shown her statements to the contrary, she says things like, that's not my words. No, I didn't say that. And then she gives a different statement. A different narrative. She said actually something else. I actually said, I can't imagine anything I would have said to him, especially in person, when we were in Leavenworth, that would have made him believe that he can get into bed with me, take my clothes off, and drug me.
I want to stop you right there, give you a little bit of context. This is an appeal of a conviction of a sexual assault, and the defense at trial was consent. And one piece of evidence that your client wanted to get in to show consent is prior sexual interactions between himself and the alleged victim. And one of these prior events was 2 months earlier in Las Vegas, when there was discussion about possibly doing a foursome, perhaps.
Yes.
Yeah. Still, wouldn't the trial court have to do a 404B analysis in order to determine whether or not something that occurred 2 months before, how relevant it is to whether there was consent 2 months later for a sexual interaction? Wouldn't there be a 404B? And when someone's talking about bondage, a foursome, that makes the alleged victim look in a way that the statute, the rape shield statute, doesn't want the victim to look.
True. So there has to be, Your Honor is right that there has to be a balancing, a 4-3 balancing of the probative value against the unfair prejudice.
Right.
And but also the balancing is different. Jones and Cox say that the balancing is different, where the evidence is central to the defense.
But is it central, something that happened 2 months before? I think it'd be different if it was the day before they had this discussion. And so, yes, maybe she did consent later that night, but this is a discussion that occurred 2 months earlier about possibly having sex as a foursome with another couple. And the further away you get from the incident in question, the less relevant it becomes. Wouldn't you agree with that?
Well, so the relevance also plays into how the cross-examination went. she was given her statements and asked.
You want to be able to show she's not truthful, and that's important. That is important.
And she says, and also she was also asked, relevant to Leavenworth, she was asked directly whether she discussed having sex before during her trip to Leavenworth, and she said she had not. And she was given her own statements to review, which said, I won't rule out that sex was a possibility. And now she denied the accuracy of the transcript. She said, that's not my words. No, I didn't say that. She said she was actually, she said something else, a different spin on it. I actually said, I can't imagine anything I would ever have said to him, especially in person in Leavenworth, that would have made him believe we can get into bed together. So she was being asked about Leavenworth specifically.
Okay.
There was two things she was being asked. One was about the Vegas incident, which she said she never had talked about having sex. And then eventually she says they could well have been some sexual talk, but only when they would get serious as a couple in 547. So she put a little different spin on it, only.
I'm going to move you to the next issue you've got because you're almost in your rebuttal time. My understanding is that the expert witness produced by the state, that she was asked a question by the prosecution that caused her to give a percentage of what percent of, she expressed an opinion about what percent of fake reports there are. And I think she said like 5%, giving the impression that 95% of the people who assert they've been raped have indeed been raped. And that's what you're talking about as far as an unfair comment on the evidence, part of your objection here, right?
Part of it, yes.
Yes. Was there an objection to her answer and a motion to strike? Because the question itself didn't really call for that 95% answer that she gave, but was there a motion to strike?
So I think the context matters of how the question came to be posed. And report of proceeding 694, in cross-examination, the defense asks, do you have any experience in dealing with people who make false reports of domestic violence? And the answer the expert gives, yes, there are some, but it's very few. It's okay. Then on redirect, the state comes in and start asking, the defense asked you about the rate of false reporting. Is there literature that can quantify the rate of false reporting? There is. I don't know right off the top of my head at the moment. And then there was a leading objection by the defense, and then they rephrased. As you recall, what is the average rate of false reporting? Less than 5%, nothing further.
Was there an objection before the answer or after the answer to that?
There was an objection to there was a leading statement,
Yeah.
but it wasn't an objection to this percentage because it just came out.
Thank you.
Did defense counsel ask the percentage?
No, this was the redirect of the prosecution. What was the average? This is the prosecution saying, as you recall, what's the average rate of false reporting? Less than 5%. So it was on redirect that the prosecution asked that.
But there was something the defense asked, though, that gave rise to this series of questions. In other words, is false reporting common or something like that? There was some question that was asked in cross.
Yes, but it wasn't an elicitation of the rates of it just says, do you have experience dealing with people who make false reports?
I see.
Not an elicitation of percentage.
All right. Thank you. You're quite a bit in your rebuttal, and that's partly our fault that happens. Thank you very much. And your answers were very helpful. Thank you. Okay, response?
Good morning, and may it please the court. My name is Michaela Meadows, and I represent the state of Washington, County of Chelan, on behalf of the respondent in this matter. I would first like to just begin by responding to some of the questions that Your Honors posed to counsel during his time. I would like to first start with what we ended with as to the expert witness, Ms. Johnson. Turning first to the record, 693 to 695, it was in fact defense who first brought that issue of false reporting to light, specifically actually asking about domestic violence, not even acts of sexual violence, to which Ms. Johnson said some, but very few.
What was the question? Be clear, what the question was that defense asked.
Do you have experience with individuals making false reports of domestic violence or something to that effect? The exact page number, I believe, is 694, Your Honor.
Okay.
To
What
which
page?
694 at the top.
The testimony that your witness gave, she didn't express an opinion about whether or not the victim was being honest or not. She just based her answer on the literature. Is that correct?
That is correct, Your Honor. She said, so the question was, do you have any experience from defense counsel in dealing with people who make false reports of domestic violence? So not NF, not victims of sexual violence even, just people, domestic violence. Yes, there are some, but it's very few. Thus opening the door to the state, then coming back for redirect, asking about that literature, and then what that percentage was, given that she'd given that some, but very few, kind of vague answer.
If there was an answer to that, the answer eventually given about 5% are false, I would think that that's probably something that would warrant a 404B objection. It's not necessarily expressing an opinion on whether this person in particular was making it up or not, but it would be something that would be unfairly prejudicial. But there was no objection, no 404B objection, was there?
There was not, and in fact, given that it was asked by defense counsel, presumably there.
I don't know how much it was asked by. I think it was more or less the answer was provoked by the redirect.
The statistic, yes, but the question of the answer of very few.
Well, the question was, do you have experience? Not what percentage. It was, do you have experience with this?
I do agree, Your Honor. However, the state does believe that that would open the door to what that percentage would be. She is an expert. She has the opportunity to speak on that, given her training and experience.
Whether it opened the door or not, the fact is she didn't express an opinion about this particular incident.
Correct. And in fact, she was very clear during her testimony that she'd not met NF. She had no particular knowledge of this case. She was just there to testify as to her training and experience with these types of issues, generally speaking.
Did Jessica Johnson comment on the credibility of NF?
She did not.
Did she indirectly comment on the credibility of NF?
Only if the court would consider speaking to her training and experience as to how victims of sexual violence may respond generally, commenting on her credibility, which is not what precedent has held.
Did the state want the testimony of Ms. Johnson in order to bolster the credibility of NF?
No, Your Honor. So the purpose of Ms. Johnson's testimony was actually laid out in the record at the report of proceedings 550 to 551, and again in the court's ruling at 567, which essentially said the court had reserved ruling during pretrial motions as to whether she would even be allowed to testify. But then during NF's testimony, there was essentially a question raised as to why a victim would respond in the ways that she did.
Does that go to the credibility of the witness?
It doesn't go to her truthfulness. It goes to the response of a person who has experienced trauma. And
which goes to her truthfulness, correct?
It does not. It just goes to explain why people might act in ways that a jury may not understand or expect.
And does that explanation tell the jury that the witness is credible?
It does not, Your Honor, because Ms. Johnson doesn't necessarily testify that these are the only ways someone might respond. There are many ways that someone might respond to trauma, which she, to the best of my recollection, did testify to, some of which did not apply to NF. There is no one way that someone responds to trauma. And the way NF responded may not have been any way that she described, because Ms. Johnson didn't know how she responded. The purpose was just to explain to members of the public, who all respond differently and may not understand different responses, that this was appropriate. Which
is the question of why someone may not act in a manner that society would expect her to act a proper subject for opinion testimony.
it is, Your Honor, when it
Is there a case that says that?
there is. It has been provided in the briefing. That is
Is it the battered woman syndrome case?
it may be, Your Honor. So she was qualified to testify as an expert, but given that she was, so the court considered and found Ms. Johnson's testimony would assist in deciding a central issue. And according to State v. Siskey, Washington courts have held repeatedly in cases involving domestic or sexual violence, it can be crucial to offer an explanation for what seems to be irrational behavior, and it's admissible evidence so long as the expert doesn't testify to the ultimate issue. And so given that that NF responded in a manner that may seem irrational and that defense counsel was alleging was irrational, hiding in the bathroom, calling an advocate instead of the police, those ways, it was appropriate for her testimony, because she certainly didn't testify that she was being truthful, that this was even a normal way of behaving, just that this was, that victims of sexual violence might act in different ways than we expect.
For an issue like this, my understanding, in order for an issue like this to be preserved, because there was no 404B objection, is that there's going to be a near explicit opinion about the alleged victim's truthfulness. And you're saying that there isn't a near explicit, you're even saying that there isn't an implied, but I think I agree with Judge Fearing that it was implied, or that it does seem to go to credibility a little bit, but it's not a near explicit.
Correct, Your Honor. So it certainly allows the state to connect the dots during closing, but that's only once the issue is raised. The court makes a finding that it's necessary. It's a key issue in the case, which the court did make that finding. And then that evidence was presented, and she did not make any sort of statement as to the truthfulness of NF.
I think it's implied a little bit, or it's testimony that tends to support the credibility of the victim, but it's not a near explicit opinion that this person is being truthful.
Correct. It's in a similar way that psychologists would be able to testify to the veracity of certain tests, I suppose, or scientific tests. It doesn't necessarily go to show that that particular incident is 100%, but it goes to show why those results are credible. For example, a BAC instrument or a toxicology result. As to the issue of the rape shield statute, Your Honor, the question of how does that not conflict with the statute, what is the reason that this information was being offered at the trial stage? And the reason that is repeatedly stated in counsel's briefing is that it was essentially to impeach her. which is the exact reason that the statute points to as not being allowed.
You can impeach a person, that's a good cross-examination. But
Certainly.
you're not supposed to make the alleged victim look promiscuous. And
Correct.
that's the thing. And when you have a discussion about a foursome with another group of people that you just met at a bar, that tends to make the alleged victim look promiscuous.
Correct, Your Honor. And the statements were introduced to show that she was lying about that previous encounter in Vegas. That is what is stated in the briefing. That is what counsel said during argument. And that even going to show that, you know, she disagreed with her previous statements. Counsel was allowed to ask those questions even, despite the fact that the process for the rape shield statute was not followed, which is under the statute, you need to file an affidavit. There needs to be a hearing. There needs to be essentially a finding, and none of that was followed. It's as Your Honor asked, you know, doesn't there need to be a 404B analysis? It's actually a completely different process.
Well, I know under the rape shield statute, you know, prior incidents with different people, you need to have that hearing. As far as between the same two people, I think it's a little bit more murky.
Pursuant to the statute, regardless, as long as it's prior sexual conduct, that process needs to be followed. Now, whether or not it is subject to the rape shield statute at all, if it's close in time with the same person, that's where it gets murky, Your Honor. However, here, there's a question of whether it was even with the same person, whether it was even really sexual conduct or a sexual, whether there was an agreement, what the conversation was, which is why there would have needed to be a hearing. Clearly, there's a disagreement here as to what the purpose of this conversation was and what the reason it was for coming in. That process was not followed here. But even if it had been, the court permitted some testimony about it. And despite all that, this is something that took place 2 to 3 months in advance, not close in time. This is something that took place not only with Mr. Ownbey, but discussing the potential with another unknown couple out at a bar in Vegas, not only 2 to 3 months in advance of this, but in an entirely different state.
Isn't there also a requirement to have sexual intercourse?
There is not that requirement, Your Honor. It's prior sexual conduct, but that includes, but is not limited to prior sexual intercourse. The rape shield statute has been interpreted broadly, provided that it's prior sexual conduct, but it does not include post-sexual
Would discussions of sexual conduct be within the rape shield? That's the thing that's why I was looking at 404B, because I don't know whether this is really captured by the rape shield statute.
And there's not really case law that the state found on that, Your Honor, but given that it was allegedly a discussion about having sexual intercourse, it is the state's position that it would fall under that rape shield statute, given that it is sexual conduct. If they're discussing having sex, if they are discussing bondage, if they are discussing consent, which are things that the rape shield statute is designed to protect from coming in without that hearing.
If you're done with answering the question, I have another question.
Yes,
for
Your
you.
Honor.
How did Mr. Ownbey gain N.F.'s trust?
The two were friends for quite some time, Your Honor. They had a business relationship. They initially met, I believe, on a Craigslist ad. He'd posted an ad looking for some sort of companionship. She had reached out, and they had an ongoing friendship from that point in time that spanned multiple years.
And is an ongoing friendship of two adults, or a business relationship between two adults considered a trust relationship under the criminal law? Do you have cases that say that?
There are not cases that say that, Your Honor, but it's simply whether there was a position of trust, and the factors that go into that essentially are as laid out in the briefing. the length of time and the type of relationship, I believe. There was a long duration. I see my time is up.
Please continue to answer the question.
And they did have a long-standing relationship. And as far as the nature of their relationship, some friendships, no, that probably wouldn't qualify. But in this instance, we see that they traveled together. Here they were going as far as to share a bed. They were indulging in things like alcohol and marijuana together. She went as far as to the best of my recollection, say she felt safe with him. I can't point to that in the record. That's just the best of my recollection from the trial. But given that relationship, that is what gives rise to that position of trust. A simple friendship or an acquaintanceship where they're not doing those things may not give rise to that.
Thank you.
Okay, rebuttal?
Mr. Okeo, would you please answer the same question reversely? Why was there not a position of trust between the two?
Sharing a bed with a woman, a 50-year-old man and a 35-year-old woman, there is no power imbalance in this situation. And there is a question on whether there was a business relationship. The evidence doesn't really seem to support that. And the state seems to be conceding that it wasn't merely a platonic relationship. And there was evidence showing that there was some discussions of a sexual nature. And where two people are flirting and they're trying to engage and they share beds when they go on different trips. There is simply not a power imbalance to sustain the special verdict that it was a violation of a position of trust.
Is there an imbalance in power when one of them's intoxicated early in the morning? Wouldn't you trust the other to kind of care for you in that situation?
But they were both intoxicated. It wasn't a situation where he was trying to take advantage of her based on being intoxicated, because the previous night before they both got intoxicated and they fell in bed together. And in this situation, the evidence actually bears out the fact that when the wires seemed to be crossed between two adults, and then when he realized that she wasn't into the aphrodisiac, all advances stopped. And then she went to the bathroom, locked herself up, and called police soon thereafter. I want to get back to briefly on the point of the rehabilitation. The prosecution claimed the cross-examination opened the door to expert testimony to tell the jury that trauma affects victims' memories, and victims may misremember, may not immediately remember details, and it may take a while to process and recall what happened. In limine, they had asked for this expert witness to explain why people who have been victims of sexual assault may not immediately leave the area where they were assaulted. Different. So Ms. Johnson is also not qualified to educate the jury as to how the brain works. She's not trained in psychology she's not an expert in memory. She's not qualified to explain to the jury how a victim's brain may remember or not remember a traumatic event. The state wanted this evidence to explain the discrepancy between the account that the complaining witness gave at the hospital.
If goes to credibility, I think you're probably going to win on that point. It was evidence admitted to sustain the alleged victim's credibility. But I do see that you're almost a minute over your time. So thank you very much.
Let me ask one
Yes,
question
please.
before Mr. Okeo sits down. Is it Mr. Ownbey's position that the rape shield statute does not apply because Mr. Ownbey wanted to admit evidence of discussions of sex rather than sexual relations itself?
Yes, I think that's.
And do you cite any case in your brief to that effect.
I think we cited that several cases, and the court was going to allow that discussion on just the discussion on sex. The court went along with Mr. Ownbey,
Okay.
but then when the witness was adamant that no discussion on sex ever happened, we were entitled now to get,
Essentially, the court changed its mind.
well, so
Is your position.
well, the court didn't change its mind. We were entitled to, the court said, show her her prior statements, and so that she can explain or deny. But then, so when she denies her prior statements and says there was still no sex, there was only sex in the context of a committed relationship, we were entitled to her prior statement to controvert this new position.
Okay, thank you. Thank you for your indulgence.
Thank you.
Following these arguments, the court affirmed the conviction and the sentence, but remanded for the sole purpose of striking the VPA and DNA collection fee. If you enjoy watching Laws Evolve in the Court of Appeals, please consider subscribing for a new video every week. Until next time.